Good afternoon and welcome to Just Jocelyn, part 2. I've calmed down slightly. I had about 3 minutes to bring my blood pressure down and try to become civil again. It won't last for very long because part 2 is as saucy and hot and disgusting as part 1. And again, my fabulous guest is Laurie Ortolano, the lady that is single-handedly with a sword, figuratively speaking for all of those of you that want to get upset, fighting for you and me, going up against the machine, going up against public servants, and I use that word intentionally, servant. Clean up on aisle 9. Who are not working for us, who are stealing our taxes, who are not writing proper policies and procedures, and then going into the court, all that with a bloated head. I don't have to. We don't have to. Things are going to change, people. And the sooner we all, you all, get educated and understand. That's why I make these little comments on the side. People go, you're annoying. Oh, well, get your own show. Problem is, we have all been indoctrinated and told to shut up and sit down for so long that we're afraid to. My body, my choice goes for masks as well. You don't tell me what to do with my body. You don't tell me to put on a mask that has God only knows what bacteria on it. That's just one little thing. But I don't want to take up the time because part 2, the Nashua Art Center. What are the dirty little secrets behind there? What are they hiding? What's the intent? Who's shuffling some stuff to who? Who's covering the back of somebody else? And why? Welcome, Miss Laurie. Did I set it up for you?
You did.
Okay.
So part 2 of my lawsuit, when I filed it in August of 2022, had another large component of it was the downtown art center and records in the possession of the city and these 2 shell corporations they formed, which were called the 201 corporations. They formed these shell corporations using an RSA 162G that made them body politic nonprofit corporations, which meant they were public bodies. Celia Leonard for the city wrote the legislation. In this court ruling, the judge made it very clear that the bylaws written were written anything but clear. He took a clean shot at her, stating that when the corporations formed bylaws, the bylaws never identified those corporations as public corporations. And they were operating those in secret meetings without proper postings.
Here we go again.
That's what was going on there. And so I ended up filing this petition on the Art Center because about November, about 10 months prior to filing the lawsuit, I was seeking these meetings. You know, where are these 201 corps? Where are you getting together? Where are you talking about the construction? We had signed all the paperwork. We got this federal money. The ground broke in April 1st of 2021. And
Sounds
it
right,
is
yes.
now October, November. And I'm, okay, where are the meetings? What's going on? I couldn't get anyone to respond to me. Tim Cummings again gave me the cold shoulder. Meanwhile, I learned after he was sitting in every one of those meetings. He was attending, representing the interests of the city with his son.
Intentionally.
Absolutely intentionally. Now, I have a bone to pick with the court on this part.
Okay.
Because Judge Temple, in my mind, and the court has completely adjudicated their, subverted their responsibilities, his responsibilities to rule on anything involving this art center.
Okay.
He has not wanted to deal with it.
So kind of hands off?
Totally. And kicking all of it out. So I ended up filing a separate suit on the profit company that was formed. It really went together with the 2 nonprofits, but he did not consolidate those. So they went into his court as a separate suit. He dismissed them. He dismissed it quickly. We had one hearing in September, and by December he wrote an order and dismissed that lawsuit, saying before he ever heard anything on records, going with McLean Middleton's brief that it was a private corporation, not owned by the company, not subject to the right to know law.
So how do you have a private corporation taking public funds that the taxpayers are on the hook for with their taxes for federal money that they asked for?
Well, that's a very good question. And that is, this was a hybrid corporation. This is a public and private. This is a corporation that was formed out of a public-private partnership, which the city never disclosed to us in this art center. I think they violated RSA 33.3, which is for bonding resolutions. If you're going to bond money and go into a public-private partnership, I believe you have to disclose that. When they wrote the bond resolution and changed it to accept this federal money, they never really disclosed that in the public hearing. That was mistake number one. So the judge tossed it out. Well, I ended up filing a Supreme Court appeal on that.
Okay.
That's up there now. I submitted my brief with a retired attorney who did an amicus, and just yesterday, McLean Middleton and the city submitted their appellate brief.
Okay.
So this is now before the court. We have an opportunity to do a reply. Considering it, don't know if I will. Maybe the court will ask for
Additional.
not oral arguments. I'm
Okay.
not certain if they'll ask for oral arguments,
Yep.
but that's up there. So down in court was this whole case on the 201 Corps. Now we have those corporations, and we have these 10,000 pages of emails, heavily redacted, that the city parsed out for 2 years. I took those emails into court separately and asked the judge to do an in-camera review on those. He ended up consolidating it into my big case. He buried me. The judge buried me. When he did the consolidation and then decided he would do the email review as part of the trial, he allocated no additional time. When he structured and pushed this right to know case out for a couple of years, he wrote an order and he said, this is a complicated case. It's got a lot of right to know in it. It's got some declaratory judgment issues I have to think about. It's not simple, and therefore the scheduling is taking longer. Okay, if he recognized that it was a complicated case, consolidating
Made it worse.
10,000 emails, redacted emails, where I had called out 200 heavily redacted emails for his review, made it worse, particularly because he decided at the end of October, 6 weeks before the trial, that he was going to do all the email review in the courtroom, but he allocated no time. So, and I was buried. I'm a pro se litigant. I have a 6-day trial in front of me. I have 5 city lawyers hired outside
Across
and
from
city
you.
lawyers who are just playing dirty every step of the way. What I found is they very willingly violated court rules, and the judge was very tolerant to that. He was willing to look the other way on a lot of that. That was very hard for me as a pro se litigant, because I'm trying to get my footing on what the rules are, and I see them, come into court and drop a document that they never gave to me right in the hearing.
That's the good old boys club.
It is. And when we went to trial, Russ Hilliard produced an exhibit book that was different from the judge's and the city's book for me. It wasn't formatted. It wasn't indexed like the city's book. And I was very upset about that. I said, that is totally unfair. Judge remained silent on that. I sent that up to the PCC, Professional Conduct Committee. Their pitch was, because the judge didn't say anything about it,
They can't do anything.
we're not going to do anything. Everyone's in bed together, okay?
Literally.
Well, I mean, it is so, it's so coupled and disappointing. So it was the most stressful thing I could have ever done. And weeks before, so the trial was 3 days. It got blown into 6 days. The first part was in December. The second part was in April. Between December and April, I started writing. And I started writing orders to the court saying, I expect a fair trial. This court has not been fair or impartial. And I've had it. And I listed out all the things that they were doing.
Yep.
And I wrote some things on my blog post about the judges not being, both civil judges in Nashua were too aligned with the city. They just were. And when I went to my trial in April, I will say that the judge had briefed for it like in detail.
Good.
He had read everything.
Okay.
That was like the first time I felt like I walked in and my judge knew exactly what he was looking at. So I will give him credit for that.
Good.
And he could summarize everything beautifully, especially on the downtown barriers. But he was punting everything on the Art Center.
On the Art Center.
He did. So when the Newmarket emails got blown in, day 2 of the trial, I realized, I took a break and I said to my friends, I cannot handle the email review. It's so uniquely different from this whole trial.
Right.
Of looking at
You can't split yourself.
I can't do it.
Yep.
I said, I'm going to have to withdraw, and I'm so upset. So on the stand, under oath, under testimony, when they were grilling me, I said, Judge Temple, I'm going to have to withdraw the Newmarket tax credit emails. But that portion of the lawsuit, and I said, it was a delay of records. Does it mean that I have to get rid of you looking at the redactions? Can you still look at the redactions? Well, I think they go together. I said, okay, I can't do it. I went home that night, I thought about it, and I came back the next day and I said, I'd really like to reconsider the redacted emails being reviewed. Before I came back by 7 a.m, the judge wrote an order saying, dismissed with prejudice. He wrote an order in like an hour and dropped it like a hot potato. It was over. And I hadn't even seen the order. I didn't realize he wrote one that fast. I don't think I've ever seen an order come out that fast. He dropped it. So I asked for reconsideration. Hilliard stood up and said, too late, she can't do it. The judge let me write one after the hearing was over. He denied it. He said,
because he had to let you do that. But he said, with the intent he was going to do that
here's
anyway.
a transcript. You said no to it. I was so frustrated with this judge because he knew he was burying me. Mm-hmm. He knew he was absolutely throwing me over, to the wolves.
Yep.
And when he decided to consolidate, which I don't think he should have done, because my Newmarket tax credit email case and review was just against the city. McLean wasn't in it.
Correct.
When he consolidated, now it's 5 lawyers.
Now you've got 5 lawyers.
Now I've got 5 to deal with that are part of this. It wasn't the same parties, and it wasn't really the same issue. The arguments and attorney-client privilege and the reason for the redactions and the arguments I was going to have to make to try and get those opened was very different from the posting of notices and meeting minutes, right?
Yeah.
And it was a whole different line of thinking, and I didn't even have time to develop my thought process to go through that. I'm a pro se litigant. I was buried. I was so upset with him. I wrote a motion to him, and I was harsh about the fact that I felt that he had really violated my due process rights. Mm-hmm. That he just basically screwed me over on this.
Yep.
And I worked so hard to get those emails.
What people don't understand is that I'm going to go out on a limb. 90%, maybe 95% of the lawyers refuse to help in constitutional matters.
Yes.
They refuse. And why? Because they are told by the court system, by the judges, by whoever, that you will no longer have your license, you will no longer get cases, and they will not go against the powers that be. So therefore, they do not take our cases. We're forced to have to learn this and take it on ourselves.
Right.
And because we do, they double down, triple down, quadruple down. They are abusive, they're threatening, they're angry, and they absolutely bury us.
Oh, yeah. And in Nashua, you look at Bolton and Donchis, they are
I've
so
met Bolton. Oh my God, at that recount.
He is such a
he hates women.
He hates women.
He hates women, and he doesn't pretend to hide it.
He doesn't. And he treats us so poorly.
He screams, he yells,
points his finger.
He calls you this close. He gets like in your face.
He calls you Missy.
And he gets so close, and there's been times that he has physically shouldered people out of the way.
Yeah, he's an aggressive man, and he is not an equal rights kind of guy at all. And so it's been, and I'm not a burn your bra lady, but man, I'm becoming one. It has been frustrating for me. Mm-hmm. So, and the courts have been very tolerant of his conduct, and that frustrates me to no end. Yep. I mean, they need to, this is a good old boys network, and it needs to change. It's very, very dated.
So just to digress for a little minute. So in my case, Wayne's case, Al's case, Karen Testerman, Dave Testerman, I'm not sure if Daniel had it in one of his, but you have no standing.
Yeah. That's
we
happened
have no
to us.
jurisdiction. So you've had it. Well, this is sort of a pat answer. You have no jurisdiction. So you have no standing. We have no jurisdiction. We're taxpayers. We are citizens of the state. We are citizens of, on federal cases, of the United States. We have standing all day long, and the Supreme Court said so. So I don't know what these lower courts are doing or what game they think they're playing, but that's what we're up against. That's what we're up against.
Right. And so, once I lost the first 18 batches, now there were 57 batches of emails coming my way. And what I had told the court during the process of him consolidating, is I said, now that you've consolidated, I got all these batches coming for another year and a half. Now I got to file a new lawsuit to have them looked at, because this one's going to be done.
Yeah.
And I went to a lawyer and I sought advice on that. And they said, you're really going to have to file a new case for the new information coming out. Because it hasn't been given.
Yeah.
So I lose on the first 18 batches. I'm heartbroken about that, but I submit a new lawsuit for the next 20 that have come out. He dismissed it.
Again?
He dismissed it, saying it was already in the first case, even though you didn't.
No, it wasn't. They're separate.
I know, but he did it. He wasn't going to hear them. And it was clear to me he did not want to look at those emails. So my friend, Laura Calhoun, was so upset by this, of all the work in those emails, she filed. She filed with another individual for an in-camera review on those emails, and she took all the records given to me. They had given her a copy of all my emails. For some reason, when the city delivered the records, they put Laura on them as well. Oh. I didn't ask for them to, but they automatically sent them. So she had them all.
Okay.
She filed a suit, and in her suit, she took on the delay of records associated with my claim. Well, Temple dismissed hers, saying you can't. You're barred under res judicata from acting on Mrs. Ortolano's claim that there was a delay of records, and the court was right. But he dismissed the whole thing and wouldn't look at the redacted emails that she got. So she wrote back very short and said, okay, I understand the dismissal, but the third part was to review the redacted emails, which were given to me.
Correct.
They were given to me. They're public records. As a matter of fact, those emails are all
gave them to him.
And now those records are all public. Anyone could come and get those records, look at them, and say, I want to have a court review them because they're out in the public.
Yep.
He dismissed it. And he wouldn't reconsider to look at them. So that's gone. So now we're dependent on somebody else, hopefully, stepping up and taking those emails and coming back into court as an independent and going after these emails again. But Judge Temple has made it very clear. I want nothing to do with this art center. He's running for the hills. So on this case, within the 201 Corps, there were some major issues. One, were the 201 Corps formed by the city under an RSA that made them body politic nonprofit corporations, which made them public entities? Were they subject to the right to know law? Because the city, Celia Leonard, never wrote any legislation or the bylaws to say they were.
So they're saying there's no right to know.
After I filed a lawsuit, Rich Landon sent an email to me, who was the president of both those corporations. He's a big contractor that works very closely with the mayor to develop downtown. And he sits as president and chair of a lot of committees, which allow no public comment, all of them. So he sent me an email after I filed the suit. Mind you, I had been working on this, and he was aware. He gave an affidavit, and I said, I was aware a year ago. She's trying to figure out what's going on. He said, I'm going to operate as if those companies are 91A. But who is he? He's just a citizen.
Right.
Are they 91A? So I wrote the lawsuit to ask the court to decide and make a ruling, a judicial ruling, a legal ruling, on if they're subject to 91A. Temple didn't do it. What he wrote in the order was that Rich Landon said they were. He's not a lawyer. And what's more important to me is that during the trial, I had Rich Landon on the stand, and I asked him, I said, do your corporations have the same employer identification number as the city? And Attorney Hilliard stood up and said, objection. That's a ruling of law. That has to be decided. That's legal. That's a legal argument.
But the judge said that
he did. Then I asked, are your companies subject to the right to know law? Hilliard stood up and said, he can't answer that. He's not a lawyer. That's a judicial ruling.
Okay, but the judge just said he could.
And the judge, no. So the judge then writes the order on June 24th and says, Rich Landon told you they were subject to 91A, so I don't have to answer that. Sorry, you do. That's your job. And then the second part was, were those companies corporations of the city? Of the city. Not that they were just public companies that were separate. But I'm arguing and presented data and information to the court that they are companies of the city. They were formed under an ordinance by the city The city gave them the same tax number as the city. The city files their federal returns. The city picks the board members that sit on them. The city has to approve the bylaws. The city has given them all their money to operate their corporations. The city is paying the interest on a loan given to them, $71,000 a year. The city is paying McLean Middleton's legal bills
fees
to represent them in this right to know case. The city is paying the insurance on the corporations. So how can you tell me they're not the city? And Mayor Donchis, in the hearing on June 17th, the budget hearing, said those individuals are individuals, those people are volunteers of the city. I agree with you, Mayor Donchis. So I said to the court, I needed the court to rule whether these corporations are corporations of the city. Why? Because my whole right to know lawsuit was written that the city was responsible for noticing these meetings.
Correct.
The court didn't rule on that. The court ruled that Joe Foster, McLean Middleton, stated that the corporations are separate entities from the city. Who is Joe Foster? He's not a judge. I took it to you.
Same thing that
He did with Rich
Hilliard
Hilliard
said.
Right, and the same thing Hilliard said. So the judge was going off of what Joe Foster said. And yet I gave all that evidence that said if they walk like a duck and it quacks like a duck, it's a duck.
It must be a duck.
He ignored it completely and just used that Joe Foster said they're separate entities from the city. So I lost all the violations for the city not posting those meetings properly because it was really McLean. He's saying the 201s had to do it. Well, in my lawsuit, my right to know petition, I didn't write that the 201s had violated right to know. I was so certain they were city entities. And worst of all, the city did not submit the answers to the lawsuit, the complete answers, until 1 month before the trial, where in those answers they said, these corporations are not corporations of the city. That was the first time I saw that. So I couldn't amend my lawsuit. I could go back right now and write a lawsuit. I filed a right to know to those 201 corps, Rich Lannon and the attorney. I said, give me all the newspaper postings and all the postings you did for those meetings because they were your companies. There were none. They never noticed them.
They never posted
because
them.
They depended on them. And I learned during the trial, those companies have a board of directors approved. They're registered with the Secretary of State as separate companies, but they're owned by the city. And they have a recording secretary. One of the board members is the recording secretary, and the bylaws say she must or he must record the minutes and keep them in a binder. They never had their recording secretary record the minutes. Tim Cummy and Amy DeRoche went to all the meetings, and Amy DeRoche, the city employee, recorded and documented all their minutes. Very poorly, might I add, with like almost no information on them, in violation of the law. So the judge never ruled on this stuff. So I lost those claims.
Wow.
And those were, so what has the judge done? He threw himself off of the new market tax credit. He threw us of emails. He threw us out of the review of all these heavily redacted emails that I think will show the fraud and the wrongdoing.
Yep.
He wouldn't rule on the 201 corps being public entities under RSA 91A as RSA 162 corporations. He wouldn't rule on whether those corporations were corporations of the city. He wouldn't rule, he dismissed immediately NPAC as a public body and just said, private corporation, you get nothing. Dropped it like a hot potato. He dismissed Laura Calhoun's case to look at those emails. He doesn't want to look at this art center. So now, if the public goes to Right to Know New Hampshire webpage, RTKNH, and you bring it up, the first article is my lawsuit, and in there is a link, and it'll bring up the 50-page order. When you look at the judge's order, the first 21 pages are all about the downtown barriers. It's very methodically written, very evidence-based. Then he breaks into the art center. It is not written the same way. It is not as evidence-based at all. It is pish-posh. It is no rulings. It is... The other thing was the city formed a capital campaign committee out of the Performing Arts Center committee. So if you have a committee in the city and they form a subcommittee, it's a public body. Well, that's what they did to raise money, the $4 million they needed, which they really raised 1.5, and they took the rest from federal money. So they formed this committee. So I argued that was a public committee because that committee was all done in the dark and you couldn't get any records. He ruled that I did not carry the burden of proof to show that that was a public committee, but the right to know law requires that the city carry the burden of proof.
Correct.
It's not my burden.
It's not your burden. It's their burden to
So,
carry.
Again, I lost that ruling because I didn't carry the burden. And I think I gave a ton of evidence that this committee was formed by the Performing Arts Center. It was a standalone committee. It had all our money into it. And then they formed a 501c3 and moved it into that. But even that 501c3 should have been a committee of the city. So now, if you look at the write-up when you get to the Art Center, it looks like it wasn't written by the same
So it was just going to come out of my mouth. I'm like, are you sure that somebody else didn't just whip that out?
So what I'm wondering, do other people write some of these orders that judges sign? Are they really the judge's order? Did somebody above him direct him on what to do with that portion? Has all of this work already been decided by upper bodies? I've got an appeal before the Supreme Court. Has the Supreme Court already decided this is a non-issue? We're going to let Nashua get away with this because there's some power here that has decided that we're not entitled to this.
Very, very odd things are happening. It's been happening for a number of years. The swamp in New Hampshire is deep and wide, and it's exceptionally black.
It's
exceptionally dirty. And the good old boys club, and they're tighter than tight. And we can't get a foot in, and we're told, shut up, sit down. This is not your battle. None of your business. You're not smart enough. It's not for you to know. We will take care of everything. And that is the problem that we are dealing with every day, in every city, in every town, in every state in the United States right now.
It's really amazing. So thank you for having me on. There's more to come on this. There's a lot of interesting things.
I can't wait to hear more, and I think everybody needs to know about this. And we've got to pick up where, you get dismissed or I get dismissed, and we've all got to know when you can stand up and when you can't, and when we need to know when to push back. But we all need to stand together, and we need to stop this bullying, threatening, and quite frankly, with no authority, breaking of law at our expense.
And we have to pray for these courts. I'm telling you, they need a lot of positive intentions.
Well, I think they all need to go. I think the law schools all need to change, and they need to be taught common law, maxims of law, foundational law, and not go by canon law. We will see you next time. Thank you, everybody, for listening, and I'll see you next week.